bottom line is financial. It's very important and it's beneficial to all clients to remain as unemotional as they can when dealing with financial issues.
Succession rights is not the same as getting on the lease. Succession means that a daughter gets the lease when the mother leaves, but the daughter does not get on the lease while the mother is still there. That means that someday, in a court, many years from now, she may have to prove that she lived there for the requisite period of time. Hear this next call.
I have a question. If you have a rent-stabilized apartment, and you're going to become like 62 and you want to go into the spree program, but you also have a sibling that you would like to have the apartment, get the apartment later on, is that a possibility or not?
Absolutely. If you are over 62 and you get into the SCREET program and your apartment is rent stabilized, if you're, that has no effect on the ability of your relative to get succession rights. Does your relative live with you?
Yes.
Okay, and how long has...
over 2 years.
Over 2 years?
Time, yeah.
Ooh, you've been to my website. You know all these standards. You know that the relative has to be living with you for 2 years.
I'm trying to get one.
Okay, well you're doing pretty good for being an analog kind of gal.
Thank you.
So anyway, so you're going to be over 62. You're going to apply for the SCREET program.
Right.
And now, have you ever gotten any request by the landlord by mail to inform him as to who else is living in the apartment?
No, never.
Good. Okay. The rule is that he has the right to ask who else is living in the apartment, and but you don't have any obligation unless he asks to provide that information. However, if you move out of your apartment, your relative would get the succession rights. And I'm sorry, what type of relative is this again?
Daughter.
Daughter. Yeah, it's pretty much a lock, especially if she can prove that she's lived there for more than 2 years.
Right.
The only snag is if the daughter lives, has a connection to an address someplace else. Is that the case?
When you say have a connection, she has a boyfriend. But there's nothing in writing in terms of another connection. You know what I'm saying?
Okay. And well, does she receive any mail
No.
over the other place?
Thanks.
Where does she receive her W-2s?
At our address.
Okay, so all the
everything is our address. The bank statements, everything.
Then you're doing fairly well.
Good.
You know? And so good luck to you. I think that you have a good situation. You're going to get SCREE. I'm going to describe to the public what SCREE is, and then your daughter most likely has succession rights. You don't have to do anything
She'll come
further
to
about
you
it.
when it's time.
Absolutely, and you know where to find me.
Yes, thank you. Bye.
Thank you.
Visit our non-commercial website at manhattanfirm.com/TV. Landlords and tenants have fought over every aspect of the rent stabilization code in the courts and the committee rooms of this state. Since only family members get succession rights, one of the big issues is, what is a family? Hear this next call.
My uncle passed away just a week ago.
I see.
And so, and now I want to, to see. I received a letter from the landlord that told me that I do not qualify to.
What was his theory?
He told me that about this new law that they passed is that that the nephews cannot or the aunts and so forth cannot succeed, succession rights. And
Did he mention the law?
he did not mention it, but he told me I have 30 days to get out, to vacate the apartment.
Did he give you a 30-day notice?
Yes, he did.
The landlord is totally wrong because, yes, they took the nephews out of the traditional family member thing, but that doesn't mean there's a bar to nephews succeeding to the apartment under a non-traditional family member status. For many years, it's been the case that traditional family members who have lived in a rent-controlled or rent-stabilized apartment for 2 years prior to the death of the tenant of record could succeed to the apartment. Now, a few years back, the law allowed for so-called non-traditional family members to also succeed. In other words, if you live with the tenant of record in a way that is equivalent to a family relationship, then you can succeed to the apartment as well if you have lived there 2 years prior to the death of the tenant of record. And that was good news for domestic partners of all types and other types of family situations where people weren't really related, but they really lived together like they were family. And in 1997, in the Rent Regulation Reform Act of 1997, they said, well, for the traditional family members, we're going to cut out the nephews.
Yeah, that's something.
So you're no longer part of the family, according to the rent stabilization. And they dropped the nephews from the traditional family member list. However, you still qualify as a non-traditional family member. The only thing I can see as a roadblock, potentially, is if there's something that I don't know about your 2 years co-residency prior to the death of your uncle. Now, like, do you live anywhere else? In other words, do you have a second home someplace?
No, I live right there for the 45 years.
Okay, that's what I want to hear. And usually when it's a winter case, that's exactly what they say. Some people will go, oh, no, I live there, but I also have this other house in Long Island or whatever. You know?
I know every inch of the apartment, the block, or whatever.
If a tenant dies and you want to succeed to the apartment, there's a good chance that you're going to find yourself in court. Now, battles over succession rights can be drawn out and complicated, and when adversaries deal with each other in court, they follow the rule of confirm and verify. The next caller is at risk of eviction at any time. The landlord stated that he and his sister can remain in the apartment for an additional 5 months over the phone, even though the tenant received a marshal's notice that the tenant would be evicted within 6 days. What would you rely on, a marshal's notice or the landlord's verbal promise? You decide.
My sister and I had the lease under our mother's name, and the landlord wouldn't put it on our name after she passed on. And what happened was they took us to court for the same issue, a legal sublet, which while my sister was under treatment for depression, I had lent it to some friends. So after that, we went to court and we made a settlement for 1 year, which ended on December 31st in 2004. However, since we're currently finishing a lawsuit, a wrongful death suit, basically what happened was they extended it for a couple of months. And now they've extended it until late April. But I wanted to know if there was any recourse on our part since the settlement has already expired.
Well, I don't know. Well, most likely you don't have a chance, and I'll tell you why. If you made a settlement in housing court, and were you represented by an attorney at that time?
Yes, we were.
And then and that settlement was an entire year ago. If in fact you had cold feet about the settlement, you would have had to have brought the case back to court to vacate that settlement within a very short time period. I would say about 24 to 72 hours after you signed the stipulation. It seems that you got 1 year to live in the apartment, and that was part of the settlement. And was there some type of monetary payment involved as well?
Well, I had to pay about 2 months arrears, and we paid the monthly rent, which is basically really low, and at the student dorm they can pretty much triple the income afterwards.